For the next session, Safari Judgments and Implications, we have Advocate K.S.Naveen Kumar. May I request Kavita Parmesh, Secretary of Bangalore Branch, to escort Sir onto the dais. K.S.Naveen Kumar is a BCom graduate. He has completed his LLB and Masters in Contract. He is practicing advocate since 2001. He specializes in GST and other indirect taxes, and he has consulting practice as well. He has appeared before various forums including Supreme Court, High Court, SESTAT, NCLT and SEBI. He provides various advisory and representational services in insolvency, SEBI and commercial court matters. He has presented various papers on indirect taxes, including GST and other topics across countries in various seminars, conferences and workshops. He has served as a co-chairman, vice chairman, member of GST or IDT committee of FKCCI. He has co-authored 3 books titled GST, a prime compendium of issues and solutions in GST, jointly published with Bharat and Tax Sutra. GST and Service Tax, a upgrade compendium, a book titled GST Appellate Mechanism. He has contributed the booklet on GST transition provision, background material on GST and material for litigation. He has taught business law, constitution and taxation as a visiting faculty in Bharatiya Vidya Bhavan, ICI, Fiscal Policy Institute and various other universities. He has addressed officers of the Central Excise, Customs, Service Tax, Commercial Tax Department and other government bodies. With this brief introduction, over to you, sir.
Good morning. At the outset, I thank the Institute for inviting me to this one-day seminar where assorted topics have been given to galaxy of speakers. I am happy to note that my friends are speaking in this seminar, and it is always a privilege to be part of such sessions where we also learn from each other. I have been given a topic which is actually limited. If you look at Safari judgment, it is about 66 or 67 paragraphs. And the focus is on trying to analyze the impact of Safari and see what is the way forward. So how many of you think that Safari judgment has given solutions for all the issues which are there in respect of all sectors? I don't see even one hand going up. Of course, I should also ask how many of you have read Safari? Okay. Safari matter it is a batch of matters. Initially it was only Safari, which went from Orissa High Court. Later on, several applications were filed by interveners before the Supreme Court. They said this judgment will also have an impact on us, therefore we also want to intervene. And some of them also filed the Article 32 petitions. And all these matters were clubbed and it was heard over a period of, I think, 5 to 6 weeks before the Supreme Court on different days. And finally it was reserved last year, but it was pronounced only recently. I think it was on 3rd October 2024. So for almost a year, we were all waiting for this judgment because the impact of the judgment, I think this ITC related issue which was discussed in Safari will have an impact on each and every client of yours. That is what appears. Now the intent of my session is to first look at what is a judicial precedent and the binding value, application of precedents in other cases, then we will go to Safari, analyze the judgment, then we will also look at the legal implications and the way forward. You may ask me a question as to why you want to start with what is a judicial precedent. Because now that Safari judgment has come, under Article 141, the law declared by the Supreme Court is binding on all other courts. So can the other courts say something other than what the Supreme Court has said? Can they disagree? No, it is binding on them. But at the same time, what is the binding value of Safari is very important. If we are able to understand this, then it becomes very clear that after whatever I analyze, it will become clear that Safari does not decide all the issues. There were only few parties who went to the Supreme Court, and whatever issues they raised has been decided by Safari. Of course, one aspect which I think the doors are closed is insofar as the constitutional validity. I don't think you can again say this restriction in the law or the exclusion or whatever, blocked credit as you call. You cannot challenge it before the court because I think it was a foregone conclusion. In fact, many of the parties in the past who approached me to go to the High Court on constitutional validity, I had discouraged them. And I have also told that because if you see the judgments of the Supreme Court itself from a very long period, wherever there is a policy matter, they refuse to interfere. So I told them, in any case the matter has gone to Supreme Court. Whatever is said about constitutionality will equally apply to you. So why do you want to go and tag yourself in those matters? The other aspect which the court has also ventured is to interpret the definition of the provisions and definitions which are there in the statute. That is where the binding value of those judgments have to be looked at. Whether they have decided all the issues is the question which we need to look at. So if you look at what is a judicial precedent, it is a judgment of a court which is cited as an authority for deciding a similar set of facts. A case which serves as authority for legal principles embodied in its decision, and it is used as a source for future decision making. So now that the Supreme Court has decided Safari, it will be very convenient for the department to adopt some of the findings there and say you are not eligible. We'll look at it how we can tackle those type of matters. Now, when the court decides something, how do you distinguish it? It is not as though whatever Supreme Court says is final. The Supreme Court itself can review its own orders. And recently, there have been instances where the Supreme Court has reviewed its own order. One judgment of canon, which was also pending for a very long time in the context of customs law, whether the DRI is the officers of DRI can issue a show cause notice under customs was an issue. The Supreme Court had initially said they don't have jurisdiction because they are not proper officers. Now that judgment was reviewed, I think that was one of the last judgments rendered by Justice Chandrachud before his retirement. So therefore, it is not as though the doors are permanently closed, but the battle will be long. Litigation will be longer. Now, what is subsilentio? When a particular point of law which is involved in a judgment is neither perceived by the court or not present to its mind. Suppose something has not been argued in Safari, you can always say that this argument was never considered, therefore it is subsilentio. It is as simple as that. And similarly, if you look at one more aspect, per incuriam. Even, the Supreme Court might have erred in arriving at a conclusion. So, per incuriam means by mistake or characterized by lack of due regard to the law or facts. We can always say, for example, I will give few examples, we will also discuss it in depth. If you look at the judgment, they would say that credit is not available to hotels and cinema theatres because it is not planned. Now, if you look at the parties before the Honorable Supreme Court, I don't think none of those parties were either hotels or cinema theatres. Does it mean that insofar as those type of associates are concerned, the Supreme Court has already decided? Then if you look at what about factory? See, if the factory is used as a tool to manufacture, in fact the Supreme Court says if a building is used as a tool to generate revenue, or it is some special structure which is put up, then you are eligible. But they are only discussing about malls and other similar type of structures. Can you say that insofar as factory is concerned, they are not eligible for credit? These are all some of the issues which may crop up because they were not parties for the Supreme Court. So you can always say that whatever observations are made, there is one more concept called obiter dicta. What is an obiter? In any case which is decided by a court, there is something called ratio, which actually is the principle which is laid down by the court. Obiter is a passing remark. To decide that issue, they would have said something. So that cannot be used as a precedent. So this is probably the way in which you should look at Safari if some issue has not been addressed. Now if you look at one more aspect, there is a Supreme Court judgment which we frequently refer. In fact, Supreme Court says this, that you cannot apply precedents by ignoring the facts. Like a Euclid theorem, you cannot apply judgments. That is why facts are important. Because law is always applied to the facts. Similarly, you cannot ignore the facts and adopt some ratio and say, this is what it is. So, Alluri tobacco case, the Honorable Supreme Court would say that you don't apply precedents like Euclid theorem. So, these are I just wanted to put this as an introduction before I move into the topic discussing the Safari judgment. Now, before that, let us also look at the provisions which were examined by Safari and what was the understanding and what ultimately the Supreme Court has decided. If you look at the provisions of 17.5C and D, which was the subject matter of dispute and challenge also, it started with a non-obstante clause and said it overrides whatever is said in 16.1, etc. Then they said ITC is not available in respect of works contract services, So C covers works contract services when supplied for construction of an immovable property. So if works contract service is provided for construction of immovable property, then they said credit is not available, but they create two exceptions there. One is other than plant and machinery. So this also became a debate. If you compare C and D, C would say plant and machinery, D would say plant or machinery. So the Supreme Court has distinguished these two expressions. So one exception is it may be for construction of immovable property, but if that immovable property satisfies the criteria of plant and machinery, then that restriction will not apply. Another exception which they said was that the input service may be for the works contract service, may be for construction of immovable property, but ultimately if it is for further supply of one more works contract service, then also this restriction does not apply. This was the understanding. This is how the law is written. Now D would say C only refers to works contract service, whereas D covers goods, services or both. So it is wider, which is received by a taxable person for construction of immovable property. This for construction of immovable property appears to be common in both. Here also there is an exception carved out. They say construction of immovable property other than plant or machinery. So there is a difference. Plant and machinery is used in C, whereas plant or machinery is used in clause D. This also was explained by the Honorable Supreme Court. But if it is on his own account, even if you are using it for furtherance of business, etc., if it is for your own account, that is, you construct something for your own use, you can take it that way, then this credit is blocked under D. So when you analyze it, this is how we were looking at the provisions all these 7 years before Supreme Court decided the matter. So a works contract service may be received, but I am also giving works contract service with no difficulty. Or works contract service for construction of immovable property, but there is some plant and machinery which is emerging. What is plant and machinery? We will come to it later. There also this block credit is not there. So credit was available. The second limb, that is D, would say, I receive the goods or services or both for construction, but it is other than plant or machinery. If it is plant or machinery, then also there is no difficulty. In fact, some of us were reading plant or machinery as plant and machinery to be on the safer side. Because when you advise someone, you cannot be adventurous. You have to be conservative. Of course, when you go to the court, you have to be very optimistic and bring out all the possible arguments. And that is what was done when Safari was being argued, saying that there is a difference between these two expressions. Then suppose I receive goods or services, etc., but it is not for my own account because I don't use that property, I give it on rent. Or in the case of manufacturers, we were taking a view that I use that property for manufacturing some goods which is supplied, therefore it is connected to the output supply which I have, therefore credit should not be denied. That is how it was being looked at. But after this Orissa High Court judgment came, if you look at Orissa High Court, they did not go into 17.5C, it was only on 17.5D. That is the second thing which we are looking at. And Orissa High Court, what they did, although it is not a very elaborate order, in one paragraph they say we read down 17.5D and therefore credit can be taken. This is how it was decided. Then the matter went to Supreme Court. So this was the understanding before Safari came. The explanation, the construction definition was there in the explanation. It was defined in a very wide manner to include repair, etc. So construction is not necessarily a new construction. It can be even repair, addition, etc. And this expression plant and machinery appears at the end of section 17, and it said it means, that means they elaborately say what it is. It means apparatus, equipment, machinery fixed to earth by foundation or structural support, because there may be big machineries which have to be fixed to earth with some civil construction also. That was also covered. It includes foundation, structural support, but specifically they said land building, civil structures are not covered. Telecommunication tower is not covered. In fact, telecommunication tower should have qualified actually. What else can you think of as plant and machinery? But somehow, pipelines laid outside the factory, they said that is also not covered. Now, if you look at the background of this entire scenario, you have to go back in the context of some of you might have practiced service tax in the past. Prior to 1/4/2011, the definition of input service was very wide, and it specifically included setting up of factory or premises of a service provider, and it would also cover activities relating to business. From 1/4/2011, they removed all these things. They made it narrower. That litigation is still happening in the Supreme Court, and the matters came up in a batch. There are about 50 matters in that batch, and time and again when those matters came, the department would take a adjournment saying that Safari is pending, therefore don't decide. Although it was interpretation of the definition. It is still pending. It is coming up again on December 20th. So the litigation in the past still continues. So when this GST came, they borrowed the same thing, and of course they structured it in the manner which we read, 17.5C and T, and all those other clauses. So the intention was not to give credit, that's all. Now if you look at the facts of Safari, as I told you, the parties mainly before the Supreme Court were malls and people who are doing renting activity, commercial renting as you call it. And Safari specifically, if you see the judgment, they narrate the facts in the very first paragraph, and they say that the party in that case was a mall. They had a mall, and that was rented out. And in the process of construction, they had used cement, steel, aluminium, etc., escalator, air conditioner, etc., and input services, and they claimed credit, department denied it. That is how the litigation started. And even the parties who joined later at the Supreme Court, they were also of similar type. So if you look at Safari, the parties who went there, all the sectors were not represented. They were mainly of these type of service providers. So that we have to bear in mind. Now if you analyze Safari, you can divide the arguments into two categories. One was on constitutionality. The other was on the interpretation of the definitions and provisions. So they not only argued on constitutionality, they also argued on interpretation. Of course, some of the parties said, I do not want to urge on constitutionality, I am only on interpretation. So these are the broad categories of arguments which were advanced before the Honorable Supreme Court. Now, after the arguments, the Honorable Supreme Court framed these issues. In fact, it is a well-written judgment. They go into various aspects. Two things I want you to read in the judgment, which is apart from what was decided in the case. One is para 6. I would request you to read it. Where they talk about the hallmark of advocacy. In fact, while they record the pleadings made by the assessees, they said that brevity is the hallmark of good advocacy. It would be ideal if parties on one side file joint submissions and the judges and lawyers are humans. Sometimes bulky compilation and submissions can be counterproductive. So this observation was made in para 6. Then one more thing which I would invite you to read is para 25 of the judgment, which captures in a nutshell the rules of interpretation of taxing statute. There are about 10 or 12 rules which are captured in a very in a concise manner, which is what referring to, apart from what they have actually decided in Safari. So these two paragraphs you can make a note of it and read it. It can be a good reference material also. Now, in so far as the constitutionality is concerned, the main argument by the party was that it violates Article 14. There is a discrimination. You are giving the credit only to few people, denying others. Then they also said that there is no intelligible differentia. You are discriminating again. Then there is no break in the chain. In fact, the other side argued that moment immovable property arises, the chain breaks. Therefore, the credit should not come. Because when you start using it for leasing, you are not going to pay tax on the building per se when you sell it later. So they say there is a break in the chain, which was also countered by the parties who appeared before the court. Then, apart from that, they also argued on cascading effect, and they also said that the provisions are invalid because it is very vague. They don't even define what is plant or machinery. There is vagueness. So these are some of the main arguments which were put across on the issue. One more argument which was advanced was on reading down. They said that you read down, like what Orissa High Court did, although it was not a very elaborate order. They continued that argument before the Supreme Court also. And at para 9, the court records the arguments relating to interpretation of the provisions. That is where the distinction between plant and machinery and plant or machinery was brought out by the parties. The main argument was plant and machinery is specifically defined in the law, whereas plant or machinery is not defined. Therefore, you cannot use the definition of plant and machinery there. That was the argument which was advanced by the parties, which was vehemently opposed by the government. They said that our intent was to use the same expression, but it was only an error that or has come instead of and, which was negated by the Honorable Supreme Court. And Supreme Court also said we cannot supply or cure deficiencies in the drafting. Now these are the issues which were framed by the Supreme Court. Whether the definition of plant and machinery applies to the expression plant or machinery, this is one question which was very important. then if it is held that explanation does not apply to plant or machinery, then what is the meaning of the word plant, and whether clause C and D and section 16(4) are unconstitutional. In fact, if you see the arguments, none of the arguments were relating to validity of 16(4), but the judgment has said 16(4) is valid. So these are the issues framed, and if you look at the conclusion, para 65 of the Honorable Court's judgment lays down the conclusion. They said that the challenge to constitutional validity is not established, so they said it is valid. Then the expression plant or machinery, which is used in 17(5)(d), cannot be given the same meaning or as the expression plant and machinery. So they said there is a distinction. And they also say a mall, warehouse or any building other than hotel or cinema theatre can be classified as a plant. This is where I was telling you, is it in the nature of an orbiter? Because those parties were not there at all. And this was mainly done because the parties relied on the Supreme Court judgment in Anand Theatre's case. And there, the Honorable Supreme Court had said that plant would not include theatres and this hotel. So that has been adopted by the court. Then they also say it's a factual question. Whether something is a plant or not is a factual question, and therefore they also bring out what is known as functionality test, and they said that has to be decided by the decided in appropriate adjudication. And insofar as the Orissa High judgment is concerned, they said they remanded back to the Orissa High Court to decide on the functionality test. As far as constitutionality is concerned, the Honorable Supreme Court elaborately borrows from VKC footsteps. Many of you would have read that judgment in GST context itself. It's a policy matter and they refer to various judgments there. Then they also say that economic laws require greater latitude when it comes to interpretation. And they also say that there should be greater freedom and greater play in the joints to the legislature. And they rule out the possibility of holding it to be constitutionally invalid. At the same time, they also state that it is not discriminatory, and how it violates 19(1)(g) or 300(a) was not elaborately argued. And Supreme Court cannot impose its view on the legislature. Then they also said that plain interpretation does not lead to any ambiguity. The question of reading down the provisions does not arise. This is how the Supreme Court ultimately decides the matter. This is the conclusion on that aspect. Now, if you look at some of the important observations, but it's an elaborate judgment, therefore it is not possible to bring everything. In fact, one of the rules, when you read a judgment, many of us, what we do is we read only head notes and try to use it as a precedent in some case. It's very dangerous. So head notes are prepared by the editorial team of the journal, and sometimes it doesn't capture. So you have to read the judgment fully, all the paragraphs, because there may be some observations on facts or law which is against you. So if you look at the judgment on interpretation of those two clauses which I had abstracted, the Supreme Court goes on to say that insofar as works contract service is concerned, the first limb, C, the benefit is not available. But they said there are two exceptions. It recognizes that there are two exceptions. It should fulfill the definition of plant and machinery. Then second exception is if you have some works contract service as an output, then also it is possible to take credit. This is how they decide. Then when it comes to the other aspect, 17.5D, they bring out the difference between C and D, particularly the phrase plant or machinery. They say it will have a different meaning other than what is defined there. And they also say that if you use those services or goods on your own account, then only credit is to be denied. Now, what is own account? This is one important paragraph which you should bear in mind. They also explain what is own account. So they say construction can be said to be on own account when it is made for his personal use and not for service, or it is to be used by the person constructing as a setting in which business is carried out. However, construction cannot be said to be on taxable person's own account if it is intended to be sold or given on lease or license. So this is one important observation of the Supreme Court which will help all those assessees. This is there in para 32 of the judgment. But when you look at the later paragraphs, although they explain what is own account, the Supreme Court links it to plant also. They said if you qualify as a plant, if the building qualifies as a plant, then if it is not for your own account, you can take credit. So why that link happened? Because the possible view was, I may not fulfill the definition of plant, but if it is not for own account also, I am eligible. So if you look at the other aspects which were discussed, they bring out the distinction between plant and machinery, plant or machinery. Now, how do you establish that? If you look at the judgment, they say that it has to be decided factually. What is plant? And how can you establish that? Maybe you will produce the engineering drawings, or you will get a certificate from a chartered engineer to establish that it qualifies as a plant. We will see some of those issues as we proceed further. Now, the court also says that we cannot add anything or subtract anything from clause C, because ITC is a creation of legislature. It can exclude specific categories. Exclusion of works contract by C will not defeat the object of the CGST Act. When it comes to constitutionality, they also said it is not a fundamental right. ITC is a statutory right. You cannot claim it as though it is your fundamental right. Therefore, restrictions are possible. That is where VKC footsteps is also discussed by the Honorable Court. They also say that the distinction between plant and machinery and plant or machinery is very consciously used by the legislature. In fact, they also refer to the model law and said that initially the thought process was to use the same expression and machinery in both C and D. But when the Act came, they made a distinction. So the court said 7 years have passed. If it was a mistake, by now you should have rectified, which you have not done. Therefore, there is a distinction. So then the court observed that the immovable property other than plant or machinery, the fact that that expression used shows that there could be a plant that is an immovable property. So just because something results in immovable property does not mean that you are ruled out. You can still say it is planned and come out of it. And they say go by commercial understanding. Here is where they said Anand Theatre's case cannot be applied in this context, and whether a mall, to decide whether mall or warehouse other than hotel or cinema theatre can be said to be a plant. And that is where they bring in the functional test. So the argument advanced by the ASG about breaking of chain was specifically ruled out in para 53, where the court said that the argument regarding breaking of chain cannot be accepted in entirety. However, if the construction of building by recipient is for his own use, the chain will break and therefore ITC would not be available. So they say building in which the premises are situated qualifies for definition of plant, then ITC can be available. So these are the conclusions reached by the Honorable Supreme Court. Now, when it comes to different scenarios, what happens to the malls now? Can they take credit based on the Safari judgment? Now, if you look at the Safari judgment, it says that if you are able to fulfill the criteria of a plant, then you can take credit. But we also saw initially that it need not necessarily be so, because once I passed the test saying that I am not using it for my own purpose and it is not on own account, then also the credit was possible. This is where you may say that it is sub silentio or per incuriam, according to me. Then what happens to hotels and cinema theatres? Although the court says other than hotel, cinema theatres, still you can say that it is only an arbiter and therefore it is ruled out. There is one more issue, interesting issue which has been raised. Suppose you take C. C is very rigid. It says that works contract services which you receive for construction of immovable property other than plant and machinery, which is defined. If I don't fulfill plant and machinery, then I cannot take credit. Now, works contract service is also a service. Therefore, can I say that under 17.5D, which covers goods or services or both, if I don't fall under C, I would come to D and say I am eligible for credit, because I fulfill the criteria of plant as laid down by the Honorable Supreme Court. This is one more argument which is possible. Of course, the department is bound to take a view that the special provision will override the general provision. All those things we will see later when they come up with that. Now, when it comes to warehouses or cold storage, which are all specialized buildings, I think there should be a possibility to take a view that it fulfills the criteria of a plant, and therefore you will be eligible to take credit. What about office administrative building? Credit, yes or no? Like corporate office or whatever. There I think you are squarely hit by that blocked credit. There is no possibility to say that it is a plant, etc. So there is a problem there. And what about plug and play workstation or co-working spaces which is created for a specific purpose, which ultimately is not for my own use, it is for others. There you can say that it is not on my own account, therefore credit should be made available. What about multi-level car parking systems, which is all created for a specific purpose? There also you can prove your eligibility. These are all some of the SSCs who are not before the court. Then what about factory? See, if there is a building like this, you bring some machinery, you do manufacture, then you can say that it is only for housing people and machinery. Therefore, it does not qualify as a plant. But suppose the factory itself is designed. In fact, I happened to give an opinion on this aspect a couple of months back, where the building itself is designed in such a way that if it is not designed that way, you cannot conduct manufacture. So those type of specialized buildings, you can say, is in the nature of a plant. Therefore, that exclusion clause, that block credit would not apply. What about lift, DG set, AC, sewage plants, etc.? There you can always say it is in the nature of plant, therefore I am eligible. So these are some of the scenarios which may arise in the context of in the light of Safari judgment. Now let us look at how much more time I have. Rajit, what is the time now? I think I have about 15-20 minutes more. I will also take questions. Now what is the possibility? From revenue side, there is already a talk that they may come up with a retrospective amendment. So the court said there is a distinction between plant and machinery, plant or machinery. Suppose in the coming budget, both the clauses they say plant and machinery retrospectively. Then what happens? They may overcome the whatever Safari. But there also, even if they do so, you would say, although I don't fulfill plant and machinery, still it is not on my own account, therefore I am eligible for credit. That argument should be still available according to me. And of course, nowadays the government is very cautious when it comes to retrospective amendments. I remember when Mr. Arun Jaitley was the finance minister, he said these retrospective amendments create tax terrorism, which they wanted to avoid. Of course, a couple of instances in the last 10 years, there have been retrospective amendments. Hopefully, they will bring some amendment in line with the GST thought process of avoiding cascading. They can also give benefit by a retrospective amendment, not necessarily to take out whatever was given by the Supreme Court. There are cases where in the last 7 years, people were not sure. So the advice was, you pay it under protest. Let us see what happens after Safari. So in those cases, you may have to look at all these possibilities, see whether it is planned or see whether it is on own account, and try to take a recredit. Then what happens to people who did not take credit at all? Can you go back and take credit now? It is not possible. The limitation will hit them. So there is no possibility in those cases. Of course, going forward, the debate continues. It is not fully resolved by the court judgment. There may be many scenarios and issues which may crop up. So the matter may again go to Supreme Court in future. Then so there are some matters which are pending in adjudication or first appeal, etc. Particularly wherever the 73 cases are there, session would have been useful to you. Suppose you feel that there is nothing to argue, then better go under that and finish it. There is no point litigating, particularly if the matters where the amounts are small. In fact, some of them paid it to avoid interest and all. Some of them took credit, but they did not utilize. Those type of cases are also there. So you can also look at the option of this scheme which has come. Then when it comes to the distinction of Safari, I have already told you how the judgments can be distinguished in general, whether it is sub silentio or per incurium or it is only an obiter. Those type of distinctions can be brought out under different scenarios. And wherever the credit has been reversed and now you feel that you are eligible for credit, you can always take a recredit of it. For taking the recredit, the time limit does not apply under law. So there should not be a difficulty in those type of cases. So these are some of the points I wanted to bring to your notice. I also want to hear from you whatever thoughts you have on this safari and its implication. I am here for a few more minutes. Yes. Mike. Just a moment. You can introduce yourself and then ask.
Yeah. Thank you, sir. Thank you for giving me this opportunity to ask questions. My name is Sangeet Lodha. My question is that I am constructing an office building, which is with the intention of construction is to rent it out. But I have also entered into a forward purchase agreement with my investor, and so it will be substantiated because this agreement is already entered that I intend to rent it out, but I also intend to sell it at a later stage. So will it qualify for?
Yeah. But I am handling a similar matter. You are saying that you have some forward contract to sell.
Right.
Whereas in my case, after a couple of years, they are already sold. Those type of scenarios are also there. I will answer my scenario, then come to yours, this one. See, when it comes to taking of credit, when I start receiving the input or input service, whatever it is, the eligibility is decided today. The later development which happens, you cannot predict today. So therefore, it may be a case, it may be a lacuna in law also, maybe they should try to introduce some amendment through 42 or 43 to plug these type of cases, where the intention is very clear that I do not want to use. So in a case like what I mentioned, I take credit on the day I am eligible. So you cannot, just because something changed after 3 or 4 years, that was not known. For the officer, after 4 years, he knows about it. But when I took credit, I didn't know. Therefore, you cannot deny the credit. That is one way of looking at it. Insofar as your scenario is concerned, your intention is not there to use at all.
So for some time I
That is how the department would perceive.
Okay, but the legal entity will hold the building. The transfer will happen through a share purchase, share sale, future.
No,
I'll transfer
are you
the.
fulfilling the criteria of it is not on own account, and or you are going to sell that.
I will sell it, but I will means the building is held by a certain legal entity. That building will still be under the legal entity, but the owner of the shares of the entity SPV, they will change. I will transfer my shares to someone else. Now that person will hold the entity and it will still
What
be.
is the effect of it?
Effect of it, I will not be the owner anymore.
So you are selling it.
Correct. Correct.
The constitution of the company is changing. Company is still the owner.
Correct. Company is still
No,
the
that is
owner.
not a case of sale.
That is the
That
share
is not a
transfer.
case of sale.
That is
You are selling the entity itself.
Yes.
That is different.
So in this case, it will be still qualified as plan.
You have to fulfill.
Yes. Because I already have a forward purchase agreement with my investor that I will not repay your loan. I
This
will
is a
pay
different
transfer
scenario
salary.
which you are mentioning.
He is not having a sale for a property, he is having a sale for shares.
Sale of shares.
That is
Yeah.
not. I thought it is you are going to sell the
No,
property.
Sale of shares. Thank you, sir.
Yes, sir. Please.
Sir, with lot of respect to you, I heard your narration on this sub silentio and the obiter dicta. See, you had a view that there are few things which has been left over in the Supreme Court judgment. So now, when you were telling about para 20 rules of taxing statute, now here the 25. Okay, sorry. So when you were talking about whether the cinema hall, hotels, whether they are left with any choice to take or not to take ITC, and the final conclusion which the court has given on plant and machinery with respect to immovable property is functionality test. You have to check for any asset of the functionality test. So I am of the view that when they were giving a order on a mall, if you go by the principle of interpretations of the statute, can I not apply the adjustum generis rule and take the color from the precedent? Because I feel cinema hall, hotels, they fall within the definition of the same nomenclature as the mall is, because the functionality test is the basis on which they have tried to distinguish. So what do you say, sir, on this?
See, if you read the judgment where they discuss about Anand Theatre, there is also a reference to Karnataka Power Corporation case. So that is where I think they distinguished Anand Theatres in that case. If you read that portion also, I was not able to abstract the entire thing. So that is why the court said we are not in a position to decide on facts. You establish on individual basis whether you fulfill that criteria. So therefore, you cannot, the court was constrained. In fact, it is impossible to say this is covered, this is not covered. If that was possible, the legislature would have said it. So that is why it was left to adjudication. They didn't want to get into that terrain because you are limiting the scope. Let us say the scope was this much. After the judgment, it would have become this much. So they didn't want to do that.
Okay. So section 17.5C and D, when we read, I am reading section 17.5C with the perspective of supplier, and 17.5D I am reading with the perspective of recipient of service. Is it correct, sir? Because the word used is
Are you
supplier.
saying 17.5C will apply to the supplier and not to the recipient?
No, like for example, if you read 17.5D, where it says goods, services, or both. So now whether this service, works contract service, which is declared in C, will it again take in D also?
No, that is a question of interpretation. Because when you are ruling out 17.5, see, works contract service is one activity which is dealt with in C. It does not deal with other services. There they put a different criteria and say that these are the cases where you are eligible, these are cases not eligible. But nothing stops me from saying I may not fulfill that earlier criteria, but I also fulfill the other one. Therefore, I am eligible.
Okay.
See, when an exclusion clause comes or any blocked credit, you have to interpret it strictly. You cannot give elaborate, otherwise everything will get out of it. There should be some scope for us also.
Thank you, sir.
Sir, in one of our clients. Hello, sir. My name is Sumana. In one of our clients' case, there is already a pre-agreement with the hospital service provider for construction of a hospital. So all the equipments and plans required for a function of a hospital is being provided. And the builder, the person who is giving the hospital building, is continuously taking the input tax credit in the GST ledgers. So, but there is still already there is a notice questioning that credit. So what is
Are
the
you from
possible-
Chennai?
No, sir, Bangalore.
In Chennai, what happened? There was one building constructed for assembly. Another party came to power, they converted into hospital. Another party constructed it for assembly, they made it library. Okay, why I am saying this is unless it is that scenario, generally you take hospital. Hospital is, let us take the operating theatre or the layout. It is all designed for a specific purpose. I have been in the hospital taking care of my mother for months together. So I know how important a room there is. It is not like a normal place. So therefore it is eminently possible that you can take a view that it is a plant.
Thank you, sir.
Department will do whatever they want, but you have to litigate. And let me tell you, that this is not going to end even at the tribunal level. Be prepared for safari too.
Their works contract was C is only.
Are you engaging a contractor who raises a bill under works contract service? This is one more thing which is, there may be cases where I myself will start buying, receiving input service, but there may be case I will entrust it to X. He will do one single billing works contract service. There you are getting it blocked. There is a problem there. But the plant and machinery, can you still say that that is where that interpretation of C is separate, D is separate will come. In your case, which clause is invoked? You remember it?
C, D, sir.
D, yeah. Then you are safe.
I think for the benefit of the participants, though it was an input tax credit and works contract, notices have been issued under 17.5D. So they have not even invoked 17.5C.
They cannot make out a better case now.
So, in fact, for that works contract, there is no dispute, so they can simply say that exclude out of it.
See, one more thing which I forgot, our friend wanted to mention in his session that section 62, 63 cases, best judgment is not covered under this scheme. You wanted to point out, sorry, I forgot in my enthusiasm to take you through safari.
Sir,
Yes, sir.
my name is Ravi Kiran. This is regarding the case being sent back to Orissa High Court to determine the functionality test. So whether this Orissa High Court will again send it to the adjudicating authority, because that cannot be a fact-finding authority.
That is a question which I also had. Because in the earlier paragraph, I think the court observed this has to be adjudicated.
Yeah.
So, in a writ petition, I think in India, Orissa High Court was a writ petition only. Fact-finding exercise is difficult. Maybe they will lay down some parameters, they will send it back.
To the
Possible.
and whether we have any judgments wherein the definition of plant and the definition of machinery has been laid out.
There
by
is one
Supreme Court.
judgment, I think, scientific engineering, income tax fund.
Okay.
They explained apparatus, plant, all those things. You can look at it.
So we can take that judgment.
That was not cited in Safari.
Yeah.
A very important judgment.
This one scientific.
I think scientific engineering or whatever. I don't remember the full. I have read it.
Thank you.
So, no questions. So I presume that you have either understood. So I thank the organizers. Over to the organizers. I thank you for your unconditional listening, and of course the debate will continue. Thank you.
There is an FAFD course which is running from December 12. If anybody is interested, please do register. There is also an BRSR course which is there. If you are interested, you can please register for those courses. We can take a lunch break and we'll assemble back at 1:45.